Hello students, how are you? So in the previous sessions, we have talked about the introductory part of company law. Then we discuss about the corporate personality concepts and the theories attached or associated with this concept. We have also discussed about the corporate aggregate, corporate soul. And in the last lecture, we have discussed about the very important question which can be asked in the exam, that is the features of company. Now, in features of company, the question can be asked like, what are the advantages of the companies? So, in that particular question, we have discussed about few important case laws like Solomon versus Solomon and Company Limited, Lee versus Lee. So there were various other case laws as well. So in this particular session lecture, we are going to talk about the other part of it. So in the last session, we have talked about the advantages. In this particular lecture, we are going to talk about disadvantages of company form of business. So as we all know, every coin has two sides. So like in company form of business also, we have to deal with the various other disadvantages. So it is not the entity which is suitable for all persons who really want to get into the business. So first we need to understand the difficulties, in case of the incorporation of the companies, or the disadvantages which are connected with the company form of business. Then only a person can take a decision whether he wants to go into the company form of business or he may go into the any other form of business. I am sure after learning all these disadvantages today in the today's lecture, you will come to know how company form of business is not always suitable form of entity for everyone. So let's get started. So if first we'll try to note down which all can be the disadvantages. So if we talk about the disadvantages, the first disadvantage we can say that there are lot of formalities. There can be formalities involved, and when there are various formalities, of course the expenses are also involved in order to comply with the formalities. So let's talk about that as well. Then we'll talk about the corporate disclosure. Corporate disclosure. Then we may talk about separation of the control from the ownership. That is, company. In order to form a company, you require shareholders, you require directors. Separation of control from ownership. So there are various formalities. There are various disadvantages. One more disadvantage is greater social responsibility. Greater social responsibility. Then there can be greater tax burden at the same time. Greater tax burden. Not always, but in certain cases. So we can put that in certain cases. In certain cases. We will talk about detailed winding up. Detail winding up, you can say the procedure. Detail winding up procedure. And the last concept, which is very important, lifting or piercing, lifting or piercing corporate will. Okay, I'll put this particular as mark this as a star, and differently we will study this particular concept, lifting or piercing of the corporate will, because this concept can be asked differently, okay, as a short note, lifting or piercing of the corporate will. Okay, so let's try to understand all these concepts in detail, okay, one by one. So when we say, okay, formalities and the expenses, what do you understand by that? So there can be various formalities, okay, for a company form of business. Okay, so in company form of business, okay, one has to comply with the first of all, the procedure for the incorporation of a company is not that easy. Okay, you require various formalities for the same. So you require various formalities. Okay, so incorporation of a company is coupled with, you can say, the complex, cumbersome procedure which is rigid in nature sometimes. Okay, so it involves considerable amount of time, it involves considerable amount of money as well. So there is an elaborate procedure laid down under the Companies Act. Okay, unlike the partnership form of business, in company form of business, one has to appoint the board of directors. There will be meetings of the board of directors, there will be meetings of the general shareholders of the company. So all these procedures have to be complied with, okay, from time to time. There are various returns which should be filed on behalf of the company from time to time, and everybody, okay, requires some cost to be paid. Okay, that is not the question if we compare this company form of business with the partnership firm. In partnership firm, we don't have to go into the meetings of the partners. It is voluntary act on the part of the partners. They may just incorporate the procedure in the agreement. But that is not the case with the company form of business. Okay, so these are the mandatory conditions, you can say, okay, where company has to go, okay, has to undergo. So various written, as I have mentioned, documents are required to be filed. There is a body called as Registrar of Companies. Okay, so company form of business is basically regulated by the Ministry of Corporate Affairs, and the Registrar of Company is the authority which gives the registration to the company. So various formalities are there which need to be complied, okay, by the company from time to time in the form of various forms. And some periodical and happening events are also there. Certain books and register, okay, there are certain mandatory books and register. I am here not talking about the labor laws. The labor laws, books and registers are mandatorily or required to be, okay, maintained by every entity, whether it is a partnership firm or a company form of business. But here we are talking about the registers like register of shareholders, register of directors. There can be register of charges, so there can be register of the key managerial personnel. Okay, all these registers are required to be maintained. Okay, again, if anything goes wrong, okay, then the liability may occur on the company, which is huge liability compared to the other form of businesses. So they sometimes it requires some sanction by the National Company Law Board, National Company Appellate Board as well, okay, or government or the Register of Companies. So if company is going for some merger and amalgamation, okay, then the sanctions are required. Okay, so if a company is going for some issue of capital dividends, then you require to take the board approval. At the same time, there are provisions where you require to take the shareholders approval as well. So try to understand, students, of any kind of breach of the provisions under the Companies Act will involve some kind of cost. So expenses or penalties can be levied on the company, and that is the reason company form of business is not, okay, it involves, okay, there are so many formalities to be complied with. So we can just conclude by saying that it is not an easy process. Okay, so it requires a lot of formalities in the form of various returns and all these things which we have already discussed, or expenses, because it always comes up with huge expenses. So let's talk about the corporate disclosure. So the elaborate legal framework, as we already talked about, designed to ensure maximum disclosure of corporate information. So whether here the members of the company, members here means we are calling about the shareholders of the company, can have considerably restricted accessibility to the internal management and day-to-day administration. So students, what happens exactly in the partnership form of business? In partnership form of business, partners can enter into some kind of partnership deed. They can decide who can do or who can perform which particular work. Okay, but that is not the case with the company form of business. Here in the company form of business has been made in such a way, or has been introduced in such a way, where shareholders are required to put the capital in the company. They can appoint the directors on behalf of them, but they cannot have the right to participate in the day-to-day operation, unfortunately. So though they are the owners of the company, okay, in the real sense what we say, but as per the act, they do not get the particular right to participate in the day-to-day operations, because they have right to take decisions from the time to time. But what if, okay, a person is holding very less share capital? Can he take the decision alone? So these are some of the difficulties faced by the, you can say, corporate world in the case of company form of business. So separation of control from ownership. So members of a company are not having effective and intimate control, that what we have seen over the working of as one can have the other form of businesses. So this is particularly in the big companies in which number of members is too large. So let's take example of the Reliance Industries or Tata's, or you can say take example of many other companies as well, where members are too large to exercise any effective control in the day-to-day affairs. So no member of a company can act in his individual capacity for and on behalf of the company, and that is the reason it has been kept very separately. Okay, the members of the company are neither the owners nor the agents of the company. So we can say the position of ownership of members is more passive in nature. So we can say that it is more passive in nature. So actually we can club these 2 points together, no doubt. Okay. So when we say ownership, ownership किसके पास है? Ownership is with the shareholders. But in actual practice, can we say that the shareholder can enjoy that ownership? So let's take the example of the Reliance Industries, where there are numerous shareholders, okay, in thousands or lakhs in numbers. Okay, so is it possible that the shareholder can take the decision? Answer is no. Okay, so the control has been really kept separately, okay, from the ownership in the case of company form of business. So let's talk about now the greater social responsibility. Greater social responsibility. So enormous powers, okay, is given to the companies and the impact they have on the society, because it may create some kind of impact on the societies, and companies are called to show greater social responsibility in this working. So there are various control and regulatory provisions given under the Companies Act. One of the provision which I would like to note over here is the CSR, Corporate Social Responsibility. Students, this particular provision has been made mandatory for the company form of business. Okay, this particular provision is not mandatory for the other form of businesses. So like in case of the partnership firm, if the partnership is earning some kind of profit, it is not required to be, the profit is not required to be shared with the society mandatorily. But this is the provision which is given under the section number 135 of the Companies Act 2013. And India is the first country to make this provision mandatory provision for the company form of business. So what does this provision talk about? As per this provision, company earning profit, there are specified companies, we will talk about that little later when we will study this particular topic in detail. The specific companies are required to incur or spend 2% of the net profit on the social activities. Now the social activities are also defined under Schedule 7 of the Act. So there are various activities defined under this schedule, and the company is required to spend that particular amount mandatorily. So even if company does not want to incur any kind of expenditure, but it is a mandatory provision. So we can say, though let's assume one particular situation where the partnership firm is also earning, for example, 10 crores of rupees profit in the financial year. At the same time, a company which is a competitor earning similar kind of profit in the company form of business. So under company form of business, company has to incur 2%, spend 2% of 10 crores of rupees. So let's take the example, 2% of the 10 crores of rupees, which will come to around 20 lakh of rupees on CSR activities. And that is the reason we can say that the greater social responsibility or the role is put on the company form of business, which is not there in any other form of businesses. So let's now talk about the greater tax burden in certain cases. So I have mentioned over here in the certain cases. So in certain circumstances, we can say that tax burden of a company is more than on other forms of business organization like partnership or any other form of business. The company is liable to tax without any minimum taxable limit as is prescribed in other form of entities. So there is a threshold given for other entities, but that is not the case with the company. So that tax implication sometimes may become very crucial. Because while taking the business decision, one has to think one has to think about the tax burden as well. So there is one more tax, which can be levied on the company form of business, which is called as dividend distribution tax. So when the profit is required to be shared with the shareholders, because why shareholders will invest money in the company form of business, because shareholder expects some kind of return on investment, that is most of the times in the form of the dividend. So in case of the dividend, a company has to give dividend distribution tax, which is in the range of 15% to 20%. It fluctuates from time to time. So the amount of the dividend may not be taxed in the hands of the shareholders, the DDT, but company has to bear that particular tax. Of course, it amounts to the double taxation, because the money, when it goes to the shareholders' hand, it is liable to be taxed for income tax. But the DDT has to be deducted from the company's account. So greater tax burden, you can say, that is not the case with the partnership form of business. In case of partnership form of business, partners may get some kind of remuneration, that may be the provision incorporated in the partnership deed, or they are also entitled for the profit sharing, because that is the main core concept of having the partnership business. So which is not the case with the company form of business. Detailed winding up procedure. So there is elaborate and detailed winding up procedure mentioned under the Companies Act. So what is meant by the winding up? First, let's try to understand about the winding up. So winding up is the process when the company comes to an end. The business of the company, or you can say the existence of the company, can come to an end. Students, if you remember, we have discussed about the provision or the concept called as perpetual succession. What is meant by perpetual succession? Perpetual succession means the company is a going concern. So even if there is a death of the shareholders or death of the directors, company's existence will not be affected. The new shareholders will come, the new shareholders will replace the deceased shareholder, the new directors will come on the board of the company, they will start taking the decisions for the company. So it is a going concern. So company's existence can only come to an end when it goes for the winding up. Now winding up is not that easy process, though it is mentioned in the law or Companies Act, the provisions are given, but one has to rigorously follow the procedures given under the Companies Act. So like winding up can be in the form of voluntary winding up, okay, commanding up can be in the form of, you can say, by operation of law, okay, so there can be compulsory winding up like that, okay. So we'll talk when the topic will come. One more point I would like to highlight over here, which I have not highlighted. Okay, let me just put that point. Company is not citizen. This is also one of the, you can say, this is also one of the drawback or disadvantage, okay, for a company form of business. So company, though we say that company is an artificial legal entity, but company cannot enjoy the benefits which are enjoyed by citizens of India, because company has been excluded from the definition of citizen. Company is not treated as a citizen. So there are some fundamental rights which are given under the Constitution of India, which are exclusively, which can be exclusively enjoyed by the people or individuals, you can say, not by the or citizens, okay. So when we say that company is not a citizen, we can take one of the right, that is right of freedom of speech, which can be enjoyed by citizen only. So company may not enjoy all these fundamental rights by not having that status as a citizen. So company, though it is considered as an artificial legal entity, but it is not a citizen in the eyes of law. Okay, so these are some of the disadvantages we have seen. Now one disadvantages, okay, is there, that is lifting or piercing of corporate will, which we are going to talk in detail, because the separate short note can be asked in the exam. So this entire question can be asked as a full length question. And the concept of this can be asked as a short note as well, okay. So you can point out, and this particular question is also expected as a short note question. So let's try to understand what is meant by lifting or piercing of the corporate will. Let me put once again. Before that, you may just, okay, note down these particular points. Please make a note of all these points. Okay, I hope you have written this concept. Now we are going to talk about the new concept which is known as lifting or piercing the corporate well. Okay, lifting or piercing of corporate well. Lifting or piercing the corporate well. Now, what do you understand by this word will? Okay, you can just call it as corporate will. So, corporate will is nothing but a kind of curtain which is put on the company. Okay, so once the company gets incorporated, we have already seen, students, in the previous lectures that company form of business gets the separate legal entity in the eyes of law. It means company starts enjoying that separate legal status from the date of its incorporation. So we can say that law has clothed a corporation with a distinct personality, but in reality it is an association of persons who are in fact in a way the beneficial owners of the property of the body corporate. So company being we can say that artificial legal person cannot act on its own. It can only act through natural person. So what does it mean? Even if the company form of business is the artificial legal person considered under the law, but the business of the company has to be conducted through various natural persons. So those natural persons can be like board of directors, the executives of the company, the top management of the company. They are going to do the business in the name of the company. So many a times it may so happen that they will start taking the undue advantage of the company form of business, and they will indulge into some illegal or unfair activities which are against the law. Now one can say that how a company can be held liable for such kind of acts, and that is the reason this concept is there called as lifting or piercing of corporate will. So even if why this concept, or why this particular you can say that why this particular concept is called as disadvantage, because in one way, okay, the firstly we are giving the status of the separate legal entity, but in some situations or circumstances the law has been given some powers to take away that particular status, or okay, to lift that particular corporate will status, separate legal entity status, to identify a person who is indulging into such activities. Okay, and that is the concept of lifting or piercing the corporate will. So the will, or you can say the curtain which is put on the company form of business, can be lifted under certain circumstances, not always. So when the situation will arise, okay, this concept can be used. So theory of corporate entity is still the basic principle on which the whole law of corporations is based. But as the separate personality of the company is a statutory privilege, what we have discussed, it must be used for legal purposes first of all, and should not be allowed to be used for illegal purposes. Okay, then when the court will think that okay, the corporate shell and which has been applied by the company for indulging into okay some illegal activities, the discretionary powers are given to the court to lift that particular well. So what exactly the court will do? Court will go into the details, court will look into the matter, and court will go behind that particular corporate entity concept and will take the action which is required. Okay, will take the actions which is required. So no entity separate from the members existed, and make the members or the controlling person liable for the activities which they have undertaken in the name of the company. Now we need to understand in which particular circumstances the lifting of corporate will can be done. So there are basically two ways. So here we can say there are some statutory provisions So under statutory provisions, corporate will can be lifted, and there can be some judicial, or there can be some judicial. Okay, so judicial, you can say with the help of the judicial or the court cases. Okay, so by judicial way also corporate will can be lifted. Okay, so now one by one we'll try to understand in which particular cases, okay, corporate will can be lifted. So let me just note down the pointers. The first pointer here, we can say that where corporate will has been used for commission of fraud or improper conduct. Okay, so where the corporate will has been used for commission of fraud, for commission of fraud or improper conduct. Okay, so this is the in this particular particular point, there was one case law which I would like to mention over here. So the name of the case law is Guilford Motor Company versus Horn. So old case law 1933. Okay, so when corporate will has been utilized for commission of any particular fraudulent activities or the improper conduct, the corporate will can be lifted by the court. So in this particular case law, what was happened? The former employee of this particular company, of Guilford Motor Company, okay, made covenant not to solicit its customers. So there was a covenant in the agreement, okay, that you will not solicit the customers of the Guilford Motor Company. But Mr. Horn had incorporated a company which undertook solicitation. Okay, so the company which was incorporated by Mr. Horn was restrained from conducting those particular activities. So what the law says that if you cannot do, you cannot indirectly, okay, indulge into such activities. So directly, what you are restrained from doing any activity, so indirectly you cannot undertake that particular activity as well. So this is the way, okay, one can be restrained. Second particular point, we can say that where the corporation is really an agency or trust for someone else. Okay, so here again we can find out one case law. The name of the case law is RG Films Limited, 1953. Okay, so under this particular case law, what was happened? Okay, well, first we'll try to understand this particular point. Let me just So here in this point we are talking about where the corporation is really an agent or trust for someone else. So there is an intention of the party that the company, other company has been incorporated just to act like an agent or trust for someone else. So RJ Films Limited, in this particular case law, there was an American company produce a film in India, technically in the name of the British company. Okay, so the film was produced in the name of the British company, but 90% of the shareholders, those who had made the capital contribution in the company, okay, was basically held by president of American company. So this that American company had financed the okay, American company had financed the production for that particular film. So Board of Trade of that time refused to register the film as a British company, stating that okay, the English company just acted as the nominee of the American company. So the intention of the incorporation, okay, intention of the person who has incorporated that company will be looked into. So one has to go behind the curtain to understand, okay, how for what particular purpose the nomination, or you can say for what particular purpose the incorporation was done. Let's first try to understand all points, then I will give you time to write down all the points. So we can say that where the doctrine conflicts with public policy, where the doctrine conflicts with public policy. So there was one of the case law, Connors Brothers versus Combs. This was a case law of 19 British case law also we are studying. So doctrine, which is doctrine of lifting of corporate will, when it is just acting or conflicting with the public policy of the time. Okay, so under this case law, the principle was applied against the managing director of this Connors Brothers company, okay, who made use of the position contrary to the public policy. So in this case, the House of Lords, because this is a British case law, understood and determined the character of the company as the enemy company, since the person who were de facto in the control of the affairs were residents of Germany. So you can say that just to understand the character of the company, so we can also put the point over here, to understand the enemy character of the company, this particular point can be used. To understand enemy character of the company, court can lift the corporate will. Okay, so the aligned enemy or the aligned company, because of this case law we can say that is not allowed to proceed with the action. Okay, so which is against the public policy, just by incorporating a company and you become the shareholder, okay, and the company is incorporated outside the other country. And see, like for example, if the company is controlled by the aligned enemy of India, okay, but when the company gets registered in India, it becomes the Indian company, though the shareholders are foreigners. So one can take the undue advantage of the Indian company just to indulge into illegal activities or activities which are against the public policy. To stop all these things, okay, this doctrine can be used. Okay. Then we can say that for evasion of taxes, evasion of taxes. Okay. Here we can put one case law. Sir T. Shaw Managing Edit. So 1927. Okay. So where it was found, what is meant by evasion of taxes? So if the company is just has been incorporated to just evade the tax liability, which is required to be which is to be paid to the government. Okay, so this particular concept can be used. So in this particular case law, it was found that the sole purpose of for which the company was incorporated or formed was to just evade the taxes. Okay, so court ignored the separate legal entity and make the individuals liable. So what was happened in this particular case law? The assessee in this particular case law was the very rich man. He enjoyed some kind of dividend and the interest income. So what he did, he formed four different company form of businesses. And after doing that, he agreed with each to hold a block of investment as an agent. So income received by him was credited in the accounts of the company, but company handed back that particular amount to him as a pretended loan. Okay, so what this particular person had done? Okay, so he basically formed four different kinds of companies, ABCD. Okay, so whatever income was he used to receive was in the form of the dividend or interest, and then again this income he used to revert back to his own account, and he used to show that as a pretended loan, and is a kind of you can say it's a kind of repayment. Okay, so this way he divided his income in four different parts to reduce his tax liability, because his income was divided in the corporate entities and the tax liability was reduced. His own sole intention was to reduce the tax liability. Okay, so in this particular case, the court disregarded the corporate entity concept on the ground that the company was formed by the assessee only to avoid the tax and nothing more than the assessee himself. Okay, so in this particular case, court removed the concept of corporate will to understand the intention of Mr. Sir Dinshaw Managing. Okay, so his intention was just to avoid the taxation. So this is a landmark judgment, you can say. I can put this judgment as an important one. Okay, because of this judgment, now a person cannot just incorporate a company just to with the view to avoid the taxation. One more point we can study. I think we have studied 2-3 points. Where the purpose of company formation to avoid welfare legislation. Okay, just to avoid welfare legislation. So when it was found that welfare legislation, so there are welfare legislation like you can say PF, PSIC, all these are the welfare legislation. Where it was found that the sole purpose for the formation is to avoid or to devise or to reduce the amount to be paid by way of bonus to the workman. Or yes, you can say bonus also. So So both just company can just by forming other entities can avoid these welfare legislations. So these are all labor laws which are called as welfare or social legislations. Okay, which are good for the welfare of the workers. But by incorporating the other entities, okay, one should not avoid the payment, which is the right of the workers. So whenever such situation will occur, the court will look into the matter and lift the corporate will. So these are the judicial precedents through which we have come to know where a court can lift the corporate will. There can be some statutory provisions like where the number drops below minimum 7. Okay, in case of the formation of the public limited company, you require minimum 7 persons as the members of the company. So where that number goes below that, the court may leave the corporate will and to try to understand what is happening behind the curtain. Okay, so these are very important points. Just make a note of all these points one by one. Okay. So first point we have discussed about the corporate will has been used for commission of fraud or improper conduct. So case study Ford Motor versus Hong 1933. Second point we have discussed about where the corporation is really an agency, just to understand whether the corporation is acting like an agent or just trustee for someone else. RG Films Limited. Third point we discuss about which is going against the corporate character, it will go conflicting with the public policy to understand the NAV character of the company. And fourth point, the evasion of the taxes. So Tinshaw Managed Petit. Please write it down. And the last point we have talked about to avoid welfare legislation. So welfare legislation like labor laws or the statutory payments which are required to be made by the company form of business. So let's quickly revise what we have done so far. So we started with the disadvantages of the company. First we talk about the formalities and the expenses, okay, which are required for the formation and for various other purposes like written filing. There are a lot of formalities involved. So if one is ready to accept these formalities, or one is ready to, on an average, if a private limited company is there, okay, one has to keep aside 30 to 40,000 for all these formalities. So if one is ready, then definitely he can think to go for the company form of business. Corporate disclosure, we have seen corporate disclosure and the separation of the control for ownership. Though you are the member or the shareholders, you cannot say that, okay, I will control everything. Of course, if you are the majority shareholder, you may have right to appoint the directors of the company. But if you are just the shareholder in the big organization, though you are called as owner, but in real sense, you will not have much authority to take the decisions. Greater social responsibility, okay, social burden is put on the company form of business in various other forms like corporate social responsibility. One example I have given to you, which is only mandatory provision under the Companies Act for company form of business. No other act is putting such kind of restriction on the mandatory position for other forms of entities. Greater tax burden in certain cases like DDT tax, you can mention over here DDT, that is dividend distribution tax, as well as the tax burden in various thresholds. Okay, there is no such minimum threshold for the company form of business, unlike other form of entities. Winding up procedure is detailed. Okay, one has to go and approach to the NCLT now. Earlier it was the cases of winding up were entertained by high courts, but now these winding up cases are entertained by NCLT, and if the appellate is there, NCLAT. Okay, one has to go and approach to these particular tribunals: National Company Law Tribunal, National Company Law Appellate Tribunal. Company is not a citizen. Company is not a citizen. Company may not enjoy the citizenship, okay, benefits, though it is called as the artificial legal person in the eyes of law. And the last lifting of piercing of corporate veil we have discussed in detail. There can be two particular provisions. One is statutory and second one is judicial. The statutory, which are under the Companies Act 2013. So if you are under the Companies Act, I have given you an example. If in case of the private public limited company, number goes below 7, then the corporate level can be lifted. You cannot continue the business of the company form of entity when you are having below 7 persons as the members for public limited company. So corporate will can be lifted. There are other formalities also where the statutory provisions can be invoked. With the help of the judicial provisions, we have understood all these points. Okay, so for the commission of the fraud or improper conduct, agency trust, and all these points. So students, so far we have completed. Let's quickly try to understand which all topics we have completed. Okay, so we have completed so-called history of company law in India. Then we have talked about corporate personality. Then we have talked about advantages of company. This particular question you can also write as features of company. Okay, why I'm writing again and again, because you should get familiar to all these questions and you will not find it very difficult, because this is a very scoring subject where you can score very good marks. And today we have discussed about disadvantages of company. So I hope you have understood all these 4 lectures so far what we have completed. So please do watch this video, do read the notes, okay, and prepare yourself. Thank you so much for attending today's session. Goodbye.